Samuel.
Good morning, Your Honor.
Good morning. We're on the record in the matter of the people of the state of Michigan versus Kelsey Lee Alvarado. This is call number 19-04939. Appearance for the record.
Yes, I was sending it to people, Your Honor.
Matthew Samuels on behalf of Ms. Alvarado, who is present via Zoom, and we waive any right to a in-person hearing that is necessary.
Okay, today is the date that was set for a sentencing. I do have a pre-sentence report dated May 2nd. Did you get a copy of that, Mr. Samuel?
I did, and I have gone over it with my client.
Okay. Your client needs to be in a place that where we can conduct a hearing. Otherwise, she can appear in person. I'm this close to getting rid of Zoom court, this close.
Understood, Your Honor. Ms. Alvarado, are you in a quiet place?
Yes, I'm at work, so I'm trying my hardest to get away from residents. I work with CMH behavioral level 4, if you guys could understand that, but I'm trying to be at the quietest place as possible.
Okay, was there a reason or need to make changes, updates, corrections, or deletions to the pre-sentence report, Mr. Samuel?
I just have one minor update on page 2 regarding employment. Says she's unemployed, but she is employed at this time.
I thought she was employed before she did this. I'm not sure why it says that. Where are you working again, Ms. Alvarado?
I work at Alternative Services Incorporated through CMH.
Your Honor, no, I'm not hearing you.
I muted it.
Oh, okay. Thank you. I thought I was losing it.
No worries. Okay. I made that update. And any other corrections or deletions?
That is all I have at this time, Your Honor.
You can make allocation.
Yes, Your Honor. I've had a chance to go over this investigating report. And the recommendations do seem appropriate at this time. I think that she can benefit from probation. However, we're currently in a felony matter that's upstairs, which will be getting probation with, as that was the term of our deal. So I think probation at this point should at least run concurrent with that charge. And possibly just let them handle the probation through circuit courts, but I'll leave that to the court's discretion.
She has a non-alcohol related charge that's before the circuit court.
That is correct.
What's the status of that?
We have a sentencing date
Ms. Alvarado,
set for July.
you have to remain still. You can't just be moving around in the middle of the hearing, okay?
Yes.
We have a
Is she
sentencing
going to
date
trial or is
set.
she gonna take it plea?
We've already pled.
Okay, and when's the sentencing date on that?
July 10th.
Okay. The report indicates Ms. Alvarado does meet the criteria for a severe alcohol use disorder. That's something that needs to be addressed. The other matter that's before the circuit court could potentially address it, but It'll be another 30 days before she's even sentenced on that. And so at this time, I'm going to sentence her to a term of probation in this court. If she does enter a term of probation before the circuit court, we don't need to duplicate her efforts. They can address that then if that's something they want to do, and then we'll amend our order or discharge her from probation here. But
Okay.
until that time, and until I can get an order, she's going to be sentenced to a term of probation so that she can get started on some programming and treatment.
Understood, Your Honor.
And so. That being said, the sentence will be 12 months probation. While on probation, Ms. Alvarado, you're not to use, purchase, or possess any alcohol or marijuana or any other controlled substance unless you have a valid prescription. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to engage in any assaultive or threatening behavior. You're not to be at any bars or nightclubs, and you are required to submit to random preliminary breath testing and or urinalysis testing, and you have to pay the fee for that, okay?
Yes, Your Honor.
Okay, there's a $30 per month oversight fee that you will be responsible for that will be assessed. I'm gonna order that you attend a victim impact panel within 180 days and provide evidence of that to probation. I'm gonna order that you attend a 12-step program as directed by probation. Do you have any questions so far?
I do not, Your Honor.
Okay, as to fines and costs, you have a $284.34 OWI cost recovery owed to the Lansing Police Department for responding to this incident. There's a $75 crime victim rights fee that will be assessed as a $50 state minimum cost that must be assessed. 12 months probation will be $360. I'll waive any discretionary fines and costs at this time. A total of $769.38. You'll make monthly payments on that, and then that amount will be adjusted if you are discharged because you'll be under supervision before the circuit court, okay?
Yes, Your Honor.
Lastly, there's an advice of rights as to probation early discharge. It states you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs, except for domestic violence, criminal sex crime, and stalking offenses, or an offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the following rights. You have the right to request early discharge from probation once you have completed half the original term ordered by the judge. Your probation officer may, but is not required to, file a notice with the judge once you become eligible for early discharge. The probation officer must send you and the prosecuting attorney a copy of the notice. The prosecuting attorney has 14 days after receipt of the notice to file written objections to early discharge. You may request an early discharge on your own from probation after meeting the following conditions. A, you have completed all the required probation programming, and B, you have not violated probation within the 3 months preceding your request. You must send a copy of your request to the probation officer and to the prosecuting attorney. The prosecuting attorney has 14 days from receipt of that notice to file any written objections. If a hearing is scheduled to address your request, you have the right to hire or retain an attorney. You do not have the right to court-appointed counsel for any hearing for probation early discharge. Lastly, you may make your request for early discharge by completing the notice regarding eligibility for early discharge from probation. That's the NC 512 form. That form is available on the court's website, okay?
Yes, Your Honor.
Do you have any questions about your advice of rights as it relates to probation, or any questions about your probation status and fines and costs?
I do not, Your Honor. Am I gonna get sent a copy or like with everything that you just said, or just what?
The probation department will be in contact with you to go over that order, and then you'll have to review and sign it and get it back to the court, okay?
Okay, thank you.
No problem. Any additional matters for the record, counsel?
From the people, Your Honor.
No, Your Honor.
Thank you. You're all set, Ms. Alvarado.
Thank you. Have a good day.
Thank you. Okay. We're on the record in the matter of the people of the state of Michigan versus Kayvon Goodman. File number is 23-00791. Council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
Matthew Samuels on behalf of Kayvon Goodman. We are both present via Zoom, and we waive any right to any in-person hearing at this time.
Date and the time set for sentencing. I do have a pre-sentence report. It was prepared on May 30th, 2023. Did you get a copy of that, Mr. Samuels?
I did, and I have reviewed that with my client as well, Your Honor.
Do we need to make any updates, corrections, or deletions?
We do not at this time.
Will you please make allocation?
I apologize, Your Honor.
You can make allocution at this time.
Okay. I've reviewed the report. I've spoken with Mr. Goodman as well. This has been a long road for Mr. Goodman. This incident happened prior to the assaultive incident that happened that he's currently on probation for. I believe that still should qualify him for 769-4A as previously agreed upon. I know that the PSI is saying that he's not qualified for that. However, this incident did take place prior to any convictions. It was just not charged until after Mr. Goodman was released from jail after serving, I believe, about 10 months. With that said, he is currently on probation. He's getting anger management service, domestic violence services. So I think probation here is contradictory and extensive at this point. But we'll leave that to the discretion of the court as he is currently serving a term of probation. I believe 2 years, Mr. Goodman.
Yes.
So far, he's been 100% compliant in 5 months. And I've noticed a major change in his behavior, and hopefully we do not see Mr. Goodman here in front of court anymore. Thank you, Your Honor.
Okay, so you're requesting 769.4A, but not to put him on probation before this court?
I mean, as long as we can make it concurrent, I realize that was contradictory. I am requesting 769-4A, whatever needs to be done to get that. But he is currently, if we can just push it in with the probation he's already serving in circuit court, that would be great. Because all the services that 769-4A is providing, Mr. Goodman is taking. And that's outlined in the PSI.
Okay, I'm just looking at the statute of 769.4A because the pre-sentence report in one paragraph says he's not eligible. Then they recommend granting 769.4A. So a lot of confusing information going on here. MCL 769.4A states that before deferring proceedings under this section, the court shall contact the Department of the State Police and determine whether, according to the records of the Department of the State Police, the accused has previously been convicted of an assaultive crime or has previously availed himself or herself of this section. If the search of the records reveals an arrest for an assaultive crime but no disposition, the court shall contact the arresting agency. The court had jurisdiction over the violation to determine the disposition of the arrest for this section. I'm inclined to believe he's not eligible.
See, and that was my confusion with reading the statute as well, was it says a previous conviction. But again, this incident did happen prior to that conviction.
It didn't say that part. That's the part it didn't say. It still has a previous conviction regardless of when the incident took place.
Okay.
And I recognize that that was something that your client took into consideration before entering a guilty plea. I don't know if you need to further consult with him before we proceed with the sentencing.
Mr.
Because if
Goodman
that's the
just
case,
confirmed that we've talked about the possibility of you not getting 769 4A and you're still okay to proceed.
That's fine.
Okay. Any further allocution, or did your client want to make a statement?
I'll leave that to Mr. Goodman if you want to make a statement. If not, we can proceed.
Okay. And you said he's on probation currently before the 30th Circuit?
Correct. It was transferred from Ionia.
Okay, and he's to be discharged within 2 years or on that probation status?
Yes.
Okay, I'm not gonna duplicate probation essentially, especially if he's not getting status under 769.4A. So the order of the court will be for the defendant to remain compliant with his probation status before the 30th Circuit Court. And so as such, there will be a 12-month non-reporting probation status before this court. As to fines and costs, I don't see that there was any restitution. There is a $75 crime victim rights fee plus a $50 state minimum cost that will be assessed. I'm also going to assess a fine of $200. The total is $325. How much can you pay today, sir?
Say that again.
Your fine in this matter is going to be a total of $325. The $200 fine plus $75 crime victim rights and a $50 state minimum cost. How much are you going to pay today?
I'm not able to pay anything today.
Okay, why is that?
Currently right now I don't have the funds. I could, if possible, I could pay it Monday.
Okay, how much are you gonna pay on Monday?
I'm sorry, Your Honor, can you say that again?
How much are you gonna pay on Monday? Are you paying the whole fine or a part of the fine?
I could pay part of the fine.
How much?
I could pay anywhere from $50 to $100.
When are you gonna pay the balance?
I can pay the balance hopefully by the end of this upcoming week.
I'll note that in the file. You can make payment by coming up to the building and making payment at the criminal traffic window, or you can mail check or money order to the court. You'll use this case number that was assigned to the case, or you can go onto the court website and make payment in that manner, okay?
Yes, ma'am.
Do you have any questions at this time?
No, ma'am.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing further, Your Honor. Thank you very much.
Thank you. Have a good one.
You too, Your Honor.
Is Patrice Gray here? I don't see Mr. Milks.
I just looked from his own record.
Okay. Mr. Abbott was here, but I don't see him right now. Not sure who this is. What's your name?
Keith Wembley.
Okay. Ms. Donnelly. Okay, Mr. Abbott is here. With Douglas Warner.
Yes, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Douglas Kirk Warner, file number is 23-01484, council appearance.
Jeff Braddock on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott, representing Mr. Warner, who's standing to my right.
Okay, today was the date and the time that was set for a preliminary examination, but due to Mr. Warner's request for representation last week and a new intake being done, we stated we would treat today as a probable cause conference. Are we going to continue to examine?
We are going to continue to examine it. Prosecutor made an offer of the aggravated assault. I discussed it with Mr. Warner and we were not going to accept it.
Due to the circumstances of you requesting an attorney last week, I'm gonna find good cause to go beyond the 21-day timeline. And if that's because you had the right to have a preliminary examination within 21 days of your arraignment, okay? And so now I have to set it beyond that 21 days, okay? We'll get your new exam date. July 7th at 10 o'clock in the morning. Do you have any questions today, Mr. Warner? Okay, any additional matters for the record today, council?
Nothing from the people, Your Honor.
Nothing from the defense. Thank you.
Bond will continue as well as the no contact order. You're all set. We'll get you a copy of your notice to appear, okay? Thank you. Okay, we're on the record in the matter of the people of the state of Michigan versus Comanche Clay. File number is 22-03119 FY.
Take just 1 second, Your Honor, to see if my witness is here in the hallway. I did not see them before I came in.
Remain there. You said Gray was here though, correct?
Yes, she's here.
Donnelly is Donnelly here?
No.
Got it. Okay, on the record in the matter, the people of the state of Michigan versus Comanche Clay, file number is 22-03-119. FY, council appearance.
Jeff Broadus on behalf of the people, Your Honor.
And good morning, Your Honor. Jared Austin appearing on behalf of Mr. Clay, present to my left in the jury box.
Okay, today was the date and the time that was set for a preliminary examination. I do have a motion to dismiss and Nolly without prejudice. So the people are unable to proceed because the necessary witnesses have failed to appear. Is that correct?
Yes, Your Honor, I've called the hallway in the courtroom and the subpoenaed witnesses in this matter have failed.
Okay, and this is not the first time this was reissued, is that correct?
Yes, that's my understanding.
Oh. Okay, the motion to dismiss is going to be granted and it's without prejudice. That means they still have the right to reissue the charge. They'll have to determine if it's in their best interest to continue to reissue the charge and haul you down here from Chippewa Correctional Facility for a victim that doesn't seem to show interest in appearing. That's up to the prosecution. You understand that, right? Do you have any questions about your rights at this time? Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing further by Mr. Clay, Your Honor. Thank you.
Thank you. We'll get you a copy of that. So that was Donnelly that you wanted. It's in custody. Is Wesley Frank here? So what's your name?
He's a victim of the 19th.
You're not just a witness. You are a witness.
Oh. Okay. So.
Thank you.
Miss Maycomb is here. Mr. Levine's that one here now.
I saw him peek in, but I don't know where he is.
Yeah. I can see if I can find him.
Please, thank you. Mr. Abbott here with Ms. Spears.
Yes, sir.
That Mr. Pfeiffer wasn't here for me, so correct, right? Just making sure. No Pfeiffer today.
I don't know what you said.
He came in and said that we're gonna run it, but I don't think that applies to us.
What's your name, sir?
Alexander Mosley.
Mr. Mosley. Mr. Goodrich. I know where Miss Donnelly is.
She's doing a random. She said she'll log in, so she.
Oh, okay, sounds good. Mr. Milks, do you have Miss Ray with you?
No.
Mr. Milks.
Yes, she is here. I just gotta go grab the hallway.
Okay. Does any minute now we're gonna have a prosecutor?
We have a prosecutor.
Well, it's
I'll do it.
touch and go somewhere. It's touch and go. It's 1 p.m. sentencing. Why is it at 1 p.m.? Or probation, or is it just a sentencing? It does have. Yes, Mr. Goodrich is on all, we can just do that one, Mr. Goodrich said, and not that one. I haven't seen Mr. Hess. Is he in the building?
Yes, Your Honor.
Oh, okay, maybe he knows what body Joe Field is.
Officer had an emergency, so I was going to do this one. I don't think I would met this down, but I got an email from George this morning. She said him stating that she would accept. Okay.
Are you ready on Miss Gray?
Um, That one, I believe, is actually going to run, Your Honor. So I believe the other ones have, are either going to be waivers or motions for adjournment. So if we could handle those first.
Which other ones?
So after conversations with Mr. Goodrich, I believe Mr. Elliott is going to waive.
I don't see Mr. Goodrich.
No, he stepped out for a minute. He's talking with his client in Mosley. I believe Mr. Abbott, after conversations, I believe indicated that Ms. Gutierrez is going to waive. And then Wimberley, I have not seen Ms. Donnelly yet.
She's doing arraignments.
Okay,
I was
I
told.
believe that one, I believe from an email I was forwarded,
Says
she's
she
going to
has
ask for an
PCC.
adjournment. So,
I have a
Yeah.
note on that one. And then did we find Mr. Levine?
I believe his client came here. It sounded from my conversations with, at least what I overheard, Ms. Maycomer, that they're going to do a plea.
Okay.
So I believe she's doing a plea sheet on that, and then I believe Ms. Housefield on this field is waiting for a defendant to show up.
We're on the record in the matter of the people of the state of Michigan versus Jessica Gutierrez. File number is 23-01246. Council appearance.
Jeff Braddock's on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Mrs. Gutierrez. She's standing to my right.
Today's the date and time that was set for a preliminary examination. How are we proceeding?
Yes, Your Honor. At this time, after conversations with the defense, I believe parties have agreed to unconditionally waive their right to a preliminary exam. And so the people would ask you to find this over to circuit court as charged in the complaint. The people have made an offer for Ms. Gutierrez to plead to 1 count of uttering and publishing. And with that plea, people would seek to dismiss the other 3 counts.
Mr. Abbott.
That's correct, Your Honor. That's an accurate statement of the negotiations at this point, and we will waive preliminary exams.
Okay. Ms. Gutierrez, how are you? I'm doing well, thank you. Do you understand that you have the right to have a preliminary examination in this file? Understand the purpose of the preliminary examination. You want to waive your right to have the prosecution meet their burden, which is to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. Anybody threatening you to get you to waive your right to examination? Any promises being made to you in exchange for you waiving your examination? So you're waiving it freely and voluntarily? Yes. You understand the waiver is unconditional. You can't change your mind once you think about it later. Okay. That's how you feel. You can sign there. Thank you.
You want to say it too?
Well, I don't know if there's a spot. Okay.
Excuse me.
Ms. Smiley, do you need to speak to Mr. Wimberly?
Yes, Your Honor, thank you.
Thank you. Find over date is going to be June 14th. That's the date circuit court gets the file from this court. You do not need to appear in court on June 14th, okay? Your next court date will be a pretrial in circuit court. Mr. Abbott will be made aware of that date. Remain in contact with him. It's also your responsibility to update the court if your address or telephone number changes at any time, okay? Bond was set at 1,000. Personal recognizance that will continue. You're still at the address on Hillborn Lane. Okay, any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense, thank you.
Thank you. You're all set, ma'am. Ready for Mr. Goodrich?
Yeah, Elliott and Mosley.
We're on the record in the matter of the people of the state of Michigan versus Lucas Walt Elliott. File number is 23-00545Y. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Elliott.
Today was the date set for a preliminary examination. How are we proceeding?
At this time, Your Honor, after conversations with the defense, I believe the parties have agreed to unconditionally waive their rights to hold a preliminary examination. And with that, the people would ask you that the people would move that this be bound over to circuit court as charged in the complaint.
That is correct, Your Honor. The defense would agree to waive the exam in this matter as well, and then we would like to address bond when appropriate.
Received your letter. It's in the file. And that will accompany you to the circuit court. I'm gonna make sure your attorney and the prosecutor gets a copy of that. Criminal, that one's not working. It's, yeah. It is the. Yeah, Hershey's. No, we ignore them, like they got their man. We told you already.
Sign this.
Okay. Okay, so. Mr. Elliott, you recognize that you have the right in this matter to have a preliminary examination, correct? You understand the purpose of the preliminary examination is to require the prosecution to meet their burden, which is to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with a crime. You understand that?
Yes, right.
You want to unconditionally waive your examination? Okay, do you understand what that means? Okay, so you can't change your mind later. You recognize that? Anybody making any threats to you to get you to waive your exam? Has there been any promises made to you in exchange for you waiving your examination? You're waiving it freely and voluntarily? I'll bind the matter over for a bind over date of June 14th. That's the date the circuit court will get the file from the district court. You do not need to appear at the circuit court on the 14th, okay? Your next court date will be a pretrial at circuit court. Your attorney will be made aware that you will remain in contact with your attorney to make sure you know your next court date, and you'll keep them abreast of any changes in your contact information, okay? Okay. Couple you wanted to address, Bob.
Thank you, Your Honor. Your Honor, Mr. Elliott's bond is currently set at 75,000 cash or surety. He has now been in jail for, I believe it's 107 days because we did have him evaluated for competency. He has been working on getting treatment on his mental health concerns in the jail. He's been getting one-on-one counseling with the therapist during that time and working with CMH. He has a house in Hastings, which is over in Berry County. It's my understanding that Ms. Kemp, the alleged victim in this case, I think lives in Eaton County. So there would at least be a significant distance between the two. He's willing to do tether or anything else that would allow him to be released. I would ask the court to at least considering, if nothing else, at least lowering the bond at this point to make it a more reasonable cash or surety bond. Down from 75,000, as he doesn't have any type of criminal history, and this is, like I said, it's a 5-year felony. I know it's a significant 5-year felony, but it is just that. Thank you.
Counsel.
The people would ultimately leave this up to the court's discretion. However, the people would just note for the record that the bond violation or the conduct here that led to this criminal charge was a result of a bond violation or a violation of a PA 53 order, I believe that was issued by this court. And that while the people would recognize that there would be a significant physical distance between the defendant and the victim in this case, that the contact that is alleged here was all done over communicative devices, specifically, I believe, text and letters. And so the people would just let, like I said, the people would ultimately leave it up to the court's discretion, but the people would just like to make that unknown for the record.
The people didn't leave it up to the court's discretion when they made a bond recommendation, and they're changing that position.
Your Honor, I would also point out that there hasn't been any allegations of him violating, trying to contact her in the 100 days he's been in jail.
You mean from the jail? Is
From
that
the
what you
jail,
mean?
yes.
Oh, because what I have, the prosecutor would have more information than I have. I have an affidavit of probable cause, which is extremely concerning. The threats, not just to the alleged victim, but threats made to his own infant son. And then a violation of a previous bond condition several times within a 7-day period, and then repeated text messages allegedly to the victim 43 times from the back seat of the Berrien County Patrol vehicle.
Your
You
Honor,
leave it to the court's discretion?
no, as I apologize, Your Honor, I was unaware that people had made a bond recommendation. I've just reviewed that bond recommendation. The people would stand by that bond recommendation.
What won't be on my head is for me to release or lower this bond, and it to be violated. This is not the first time that Mr. Elliott has shown the courts that he doesn't follow the court order as it relates to no contact. The bond was set because of that at 75,000 cash shorty with a GPS tether. It says 2,000 feet exclusion zone. I'm trying to read this handwriting. So I think it's GPS tether order. I think the bond was appropriately set based on the charge and the concerns that the court had and the multiple violations of a previous no contact order. So the bond motion is denied. You can obviously renew your motion before the circuit court. At this time, bond will continue as set. We'll get you a copy of this. Our printer is not printing it here in the courtroom. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Thank you. You're all set. Okay. Copy of that, I guess. I need to do it more anyway. Okay. Mrs. Mosley. We're on the record in the matter of the people of the state of Michigan versus Alexander Mosley. File number is 23-01378 FY. Council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Mosley, who's standing to my right.
Okay, Mr. Mosley, today was the date set for preliminary examination. How are we proceeding, council?
Yes, Your Honor, as you stated, today's the date and time set for preliminary examination. The people did subpoena witnesses, specifically the arresting officer in this matter was Officer Bailey Uberoff. I was in contact with Officer Uberoff last night, and they indicated that they would be here today. However, I received a second email at 5:55 this morning, where Officer Uberoff informed me that they were at Sparrow Hospital. They had been there since 9 last night with a family emergency and would be unlikely to make it today. So with that, the people would ask that the court find good cause to adjourn this preliminary examination.
Council.
Your Honor, I certainly sympathize with his family situation, but I would like to point out to the court that Mr. Mosley was previously charged for this same offense. Officer Uberoff failed to show up on March 10th. They rescheduled the preliminary exam. They adjourned it for him. He failed to show up on April 21st. The case got dismissed. The prosecutor's office chose to reissue the case. This is now the third time there's been a preliminary exam where Officer Uberoff has not shown up. So at this point, Your Honor, we are asking for this matter to just be dismissed.
Is that accurate?
I know we've reissued this case at least once. As to the exact timeline, I see no reason to disagree with what Mr. Goodrich has alluded to before too.
You said it was previously set for a preliminary examination in March, and the
Yes.
officer failed to appear,
Yes,
and then it was reset in April,
yes,
and the officer failed to appear.
yes. And one of those times he was on vacation. I don't remember. I didn't see what the other was.
Okay, you advise your client that if I grant your motion, that the prosecution has the right to reissue, and you have to repost bond.
He is aware of that. And he said he's been through the process once already.
Motion
Redoing
to
it.
dismiss is granted. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor. Thank you.
Thank you.
I think it's because that was really light.
Bobby Joe Fields here? Do we know if Bobby Joe Field is here and Mr. Hess? We don't know.
Mr. Hess, I believe, I know I saw him earlier.
Okay,
Might be with Judge Ward.
okay, I don't know if this client is here. Oh, Miss Donnelly. We're on the record in the matter of the people of the state of Michigan versus Keith Wimberly. File number is 23-01411. Council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Keith Wimberly Jr., who is appearing separately by Zoom.
Okay, today was the date and the time that was set for a preliminary examination. However, I did note that I would be treating today as a probable cause conference. I know the parties were negotiating a possible misdemeanor offer or to have the defendant screened for I believe, drug court. How are we proceeding at this time?
Your Honor, I did have a chance to talk to his case manager. Mr. Wimberly has some mental health diagnoses that I think qualify him better for mental health court. But at this time, Mr. Wimberly he was on probation in Eaton County. And he had a sentencing on a violation based on this case this morning, and they've sentenced him to TRICAP. He's currently in the parking lot waiting to talk to his probation officer so that he can learn more about when he'll have to go to TRICAP. But at this time, like I said, I believe that we're still working on a misdemeanor offer. I would like to waive the timeline so we can keep it here in district court and then adjourn, have a probable cause conference later when we have more information and I've had a chance to talk to his probation officer.
Okay. So based on that information, I'll find good cause to go beyond the 21-day timeline. And then we'll get this reset so that you can find out more information and continue your negotiations. June 29th at 8:30. June 29th at 8:30 for another probable cause conference. Oh, yeah.
July 7th at 10.
July 7th at 10 will be the next date for a preliminary examination. Any additional matters for the record?
Just briefly, Your Honor, I would just like to put on the record that I was forwarded an email by another APA in our office from Assistant Public Defender Donnelly, which essentially said the same thing that she said here on the record.
Okay,
So people have no objection to that.
sounds good. Any additional matters from you, Ms. Donnelly?
No, Your Honor, thank you.
Thank you. You're all set.
Thank you.
Okay, wonderful. Mr. Hess is not yet. Okay, sounds good. We're on the record in the matter of the people of the state of Michigan versus Wesley Frank. File number is 23-01251. Council appearances.
Morning, Your Honor. Natalie Baker on behalf of the people.
Morning, Your Honor. Attorney Barnett Levine on behalf of Wesley Frank. He's present, standing on my right.
Today was the date and the time set for preliminary examination. However, I said that I would treat today as a probable cause conference. We will adjust the timeline as necessary. How are we proceeding?
Here is my understanding that we will be entering a plea to an count 2 animals abandoning of cruelty to one animal contrary to MCL 750.504A. The 93-day misdemeanor and or $1,000 in fines. Consequential plea, the people would move to dismiss the original count 1. There's also a Killebrew agreement to no further upfront jail at the time of sentencing, so long as the defendant agrees to any and all terms of probation as deemed appropriate at sentencing. The people do consent to treatment under HYTA status if the court finds the defendant eligible. The consent is based on the defendant's age. He was 22 at the time of the offense.
It's an accurate, complete statement.
Okay, Mr. Wesley, I'm sorry. You heard it's Wesley Frank?
It's Mr. Frank.
Okay, Mr. Frank. You heard the offer that was stated by the prosecutor?
Yes, Your Honor.
Okay, and you want to accept that offer today?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can put your hand down. I do have an advice of rights and the information sheet has today's date on it. This is your signature?
Yes.
You read this document?
Yes.
You understand the rights listed here?
Yes.
Do you have any questions about any of these rights? Okay, so you're willing to give up your right to a trial on this matter?
Yes, Your Honor.
Okay, you understand that you have the right to the presumption of innocence. So that means you're innocent, and you're innocent until the people can prove you guilty. You have the right to require them to prove you guilty at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You want to give up that right? You don't have to give it.
Yeah.
Well, I asked him.
No, I know you asked me,
I'm
Your
just
Honor, but
confused.
You don't have to give up your, I asked you if you want to give up those rights. You said, you said you did not want to give up the right.
Your Honor, if I
So
may,
like trial?
Yeah, your right to a trial and your right to the presumption of innocence. You told me you read this document and you understood all of the rights that was listed here, correct?
Your Honor, if I may, I just have to object to something, just to clarify. It's not that he doesn't understand. but he has a learning- He has a
don't,
condition where he can't take all that information.
okay, okay, there's, but you read and you understood this document, correct?
Yes.
Are you
somewhat.
sure? Is you said, yeah, somewhat.
I read over it. I just, like when you asked the question, I kind of got a little confused.
I understand that, but now I'm going back to this question. You understood all the rights that was listed here?
Yes.
Okay, and it has to be your understanding, not your attorney's understanding. You understand that? And if you don't understand, then you just ask for more time because the court can give you more time to go over that. You recognize that?
Yes.
Okay, and so the first one on here, it gives you, it talks about your right to a trial. You have the right to have a jury trial. You understand that?
Yes.
Okay, and you understand that the purpose of the jury trial is to require the prosecution to prove your guilt.
Yes.
And you have the right to have them prove each element of the charge being brought against you. They have to prove each element beyond a reasonable doubt before you're guilty. Otherwise, you're considered innocent. So as you stand here today, you're innocent until they can prove you guilty. You understand that?
Yes.
Okay, you want to give up those rights. That is the right to be considered innocent until proven guilty. And you want to give up your right to have a trial. Is that correct? Okay. And you also want to give up your right to cross-examine any other witnesses that they intend to call?
Yes.
You want to give up the right to call your own witnesses or present evidence that you believe further a defense to the charge being brought against you?
Yes.
You want to give up the right to remain silent and not have silence being used against you at a trial?
Yes.
Okay, anybody threatening you to get you to give up your rights today?
No, Your Honor.
Has there been any promises made to you in exchange for you giving up your rights?
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
Okay. You understand that a guilty plea can result in a conviction that you may need to report to your job.
Yes, Your Honor.
Guilty plea can result in a conviction that may have impact on any travel or immigration status that you may be seeking.
Yes, Your Honor.
Okay, and understanding that you still want to give up the right to plead guilty, correct?
Yes.
Okay. Lastly, are you pleading guilty because you believe you're guilty?
Yes, Your Honor.
Okay. As to the added count of count 2 of animals abandoning cruelty to one animal, you plead guilty, not guilty, or stand mute?
I'm guilty, Your Honor.
Okay, so then two other things is, there is a Killebrew agreement of no upfront jail at the time of sentencing, as long as the defendant agrees to any and all terms of probation. That's an agreement between the three of you sitting here. I'm not a party to that. You understand that?
Yes.
So if I decide that I'm going to deviate from that agreement, I would give you the right to withdraw your plea at the time of sentencing, okay? Okay. Factual basis.
Sure, thank you, Your Honor. So I'm going to ask you a series of questions similar to what we talked about before. You have to answer clearly and be definitive, please. Okay.
Okay.
On or about 12/17/22, were you at 2800 Beaujardin Drive, apartment 304, City of Lansing, State of Michigan?
Yes.
Okay. While there, did you own a slightly undersized 1-year-old male dog Rottweiler named Roscoe?
Yes.
Okay, and in a view that you now understand is wrong, you now know that it's wrong, but you didn't back then. You purported to discipline the animal by striking the animal in the head, correct? And you struck the animal in the head with your hand, correct?
Yes.
All right, and the effect of you striking the animal is that the animal had a cut over its eye where you struck, where you hit the eye, correct? You understand that?
Yes.
All right, Your Honor, I believe that the offer circumstances are sufficient to sustain factual.
Any questions from the prosecution?
No, Your Honor.
The court is satisfied with the factual basis. We established the address. That was in the city of Lansing, Ingham County, state of Michigan. The
Yes.
address, okay. The court is satisfied with the factual basis. I'll accept your plea, finding your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. It's going to be July 27th at 8:30. When you leave here, you need to go downstairs to our probation department. They're on the 5th floor, so they can get you set up for a pre-sentence interview, okay?
Your Honor, I'm sorry, I may have a conflict that morning at Livingston County. At circuit court, I believe I do. Is there any way that we can push that out a little bit later that same week?
It has to be a different day. We can do on Monday, August 7th at 8:30.
That'll be fine. I appreciate it. Thank you, Sarah.
August 7th at 8:30. Okay, so you know where you need to go when you leave here today, sir?
Probation area.
Yep, down to the 5th floor to meet with probation, so they can get you set up for your interview. So they can provide the court with a report regarding how you should be sentenced, okay?
Okay, Your Honor.
Do you have any questions for the court?
No,
Okay, any additional matters for the record, counsel?
None, Your Honor. Thank
No,
you.
thank you. Thank you.
Let's see. Mr. Hess is here. Are we running field?
No, Your Honor, there'll be a waiver of Freeland. I just have to find the prosecutor.
Thank you, Your Honor.
Thank you, have a good one.
You too.
On the record in the matter, the people of the state of Michigan versus Bobby Joe Field, file number 21-02067. Council appearance.
Thank you. Good morning, Your Honor. Erin Housefield on behalf of the people.
Thank you, Your Honor, and good morning, Edward Hesselman at Bobby Field. Mr. Field is to my right at the council table, and we haven't signed any waivers if that's required.
That's when you're waiting.
Yes.
That is correct.
Okay, is there an offer?
Yes, Your Honor, thank you. The offer is for the defendant to plead as charged to 3 of the 6 counts. And upon successful plea and sentence, the remaining 3 will be dismissed.
Mr. Hess?
That's correct, Your Honor.
And Your Honor, if I may also note for the record, I've just advised Mr. Hess, there's only one address listed on the complaint. When the people file the information at arraignment, there will be an address listed for each of the 6 counts. So we are waiving on the complaint as filed with the understanding that the addresses will be corrected at arraignment.
Okay, sounds good. Okay, Ms. Field, you understand that you have the right to have a preliminary examination here in the district court. You understand the purpose of the preliminary examination? Do you understand the purpose of the preliminary examination? So you're willing to waive your right to have the prosecutor meet their burden, which is to establish if they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime, correct? Anybody threatening you to get you to waive your exam?
No.
Has there been any promises made to you in exchange for you waiving the examination?
No.
Are you waiving it freely and voluntarily?
Yes, I am. This appears to be the only one, Your Honor, without a spot for prosecution.
Sounds good.
Your Honor, for the record, we have received the paper examination waiver form and client and I are in the process of signing it.
Thank you.
Your Honor, and thank you. Your Honor, may I approach the?
Yes, thank you. Oh. The bind over date, ma'am, will be June 14th. That is the date the circuit court will get the file from the district court, okay? You do not need to appear in circuit court on that date, okay? You do not need to appear. This file will appear over there on that date, okay? They'll then set your next court date, which will be a pre-trial. Mr. Hess will be made aware of that. You remain in contact with Mr. Hess, okay? You'll also keep the court and Mr. Hess updated with any changes in your contact information, okay? You still have the address on Birchfield?
No.
Let me see here. That should have changed. Oak Road?
No.
You changed addresses since being arraigned on the 18th?
Yes, I did. I gave it with pre-trial services.
Okay. What is your address?
14200 Boyshot Road, BOICHOT. That's the land name.
Oh. Is it a house or is it an apartment?
House.
Okay. Okay, your phone number still ends in 2622. Bond was set at 10,000 personal recognizance that will continue. Any additional matters for the record?
Nothing for the people. Thank you, Your Honor.
Thank you very much.
Thank you. You're all set. Mr. Johnson.
Johnson matter, I was talking about. Do you have a pre-sentence report for him? I never got. I was gonna go down to the. Yeah, there was one first.
There is one here. No, there's two separate ones, or it's the same one? Mr. Lee give his? Yeah. And I sent it to Mr. Goodrich too. I can forward it to- They were running an exam on, right?
Yes.
We need a prosecutor.
I don't.
Well. The court does.
That's fair.
You can handle both roles.
Yeah.
I don't know.
Okay.
I don't know that you could. And someone also contact Mr. Lee and see if he will be available after this examination to do the sentencing. Mr. Addy, you back from there?
I am, Your Honor. I have a question about Jason Murray.
Hopefully I have an answer.
I had a PCC last week and my notes are that we left it on for this week's preliminary exams, but it's not on the schedule this week. The person that's in custody in Clinton County.
Oh, no, it's what's gonna take more than a week to writ them. They need at least 10 days to writ, I think. It's the 22nd. The 22nd.
May not be in jail. So, lives in a tent by the railroad tracks near Pennsylvania Avenue.
Unfortunately, they don't let us do a 7-day writ. Sometimes the 10-day writ don't work. Like the sentencing, we tried to do yesterday. That never happened.
She just signed another one.
Yeah, so we'll see.
So,
It's being held on something over there?
He was just going to be sentenced, I think this week, and he, based on my conversation with him, he thought he might get released at the date of sentencing. Time served. So,
What's his bond on ours?
pardon me?
What is his bond on my matter? PR 3,000. What's the charge? It's small. Put in the file. I'm in the bond. He won't be released.
Stayed away.
You gotta make sure he gets here.
You get the file.
Right. What was it, the 27th?
Yeah.
Yeah. See?
Yeah, make sure he gets to court, get this resolved. I don't want this lingering all summer.
I'm fine with that.
I'm sure. Like, doesn't he have GPS?
Yes.
It's not GPS.
Okay.
We'll find it.
All right, good. Wish they would give us access to that information, to find their clients.
Well, that's half the battle. You all finding your client, get him in court. On the record, in the matter of the people of the state of Michigan versus Patrice Gray, and file number 23-00751, FY council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
Good morning, Your Honor. Stephen Milks on behalf of Ms. Gray, who is present and seated to my right at this time.
Okay, today's the date set for preliminary examination. Any preliminary matters before we proceed?
Nothing from the people, Your Honor.
Your Honor, I believe we can probably just stipulate, I think there's two prosecutors' evidence.
I only
Proposed evidence?
one exhibit, and then I was just gonna walk through. I wasn't planning on today. I was just gonna walk through with the.
Okay. Then I guess just one proposed exhibit which will stipulate you regarding video, Your Honor. I believe it's being chalked up on Zoom right now. We'll just stipulate to that.
Okay. Has that been numbered?
Yes, Your Honor, that would be people's exhibit.
Okay. Without any other preliminary matter, you call your first witness.
Yes, Your Honor, the people would call Ms. Tara Richmond.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Yes. You can have a seat there. Okay, so there's a microphone that's in front of you, and the lady behind you is my court recorder. She has to take down everything being stated here today. So your responses must be verbal, loud, and clear. We can't do head nods or head shakes or mm-hs and uh-hs because she can't write that into the record, okay? Also, we got these glass things right here that blocks the sound. You're answering their questions, but it's for my benefit. So I need to be able to hear you, and she has to be able to pick it up. So that microphone there is helpful for her, okay? Lastly, if there's an objection made by either of the attorneys, you would stop speaking. I'll make a ruling on the objection, and then I'll tell you if you can give that answer or not, okay? State your first and your last name, then spell both of them.
Sarah Richmond, CARARICHMOND.
You can proceed, counsel.
Good morning, Ms. Richmond. Apologize for the long morning. Ms. Richmond, do you know an individual by the name of Patrice Gray?
Yes.
And how do you know Ms. Gray?
I used to work with her.
And where did you work with her?
In St. John's at Swan City.
Okay, and you say you used to work with her. When did you, I guess, stop working with her?
December 2020.
Okay, and when, I guess, when did Miss Richmond, were you working at that business when Miss Richmond started working there?
No, I was working there for her.
Yeah, were you working there when she started?
Yes.
Okay. And when was that roughly?
Probably started in May of 2020.
Okay.
I started in March of 2020.
Okay, so I guess then how long roughly in years have you known Miss Richmond? Or Miss Gray, sorry, Miss Gray.
I don't really know her that well, but I've known her since 2020, so about 3 years.
Okay, and do you see Miss Gray anywhere here in the courtroom today?
Yes.
And can you identify where she's seated and an item of clothing she's wearing?
A gray shirt and glasses, sitting at the table.
Okay, let the record reflect the witnesses identified the defendant.
Your Honor, I identified him as knowing her not as to the allegations in this matter at this time, so it's not an identification of actual personal knowledge of the incident that occurred or anything along those lines. But we'll stipulate the fact that she
She knows who she is.
knows who she is at this point, Your Honor.
We should do identification a little later.
Yes, I just wanted to establish that the victim knows who the defendant is.
Okay, sounds good. Thank you.
Okay, so, Ms. Richmond, I want to take you back to the night or morning of November, on or about November 28th, 2022. Were you in, do you recall that date?
The night or the morning. It happened about 11 o'clock, but I was not there.
Okay, so it would be the night of November 11th, or sorry, November 28th, or November 27th, 2022 into the morning of November 28th, 2022.
Yes,
Do you remember that time?
yes.
Okay, and where were you at that time?
I was at a bar for a birthday party.
Okay, and who were you at the bar with?
My friend and his family.
Okay, and prior to going to the bar, were you anywhere before that?
No, I was at home.
Okay, so did you meet those individuals at the bar?
No, so I had parked my car in the street and then we all rode to the bar together.
Okay, and where did you park your car then?
It was at the street of my friend's house.
Okay, and in relation to your friend's house, where was it?
Parked directly in front of the house.
Okay, and do you recall that address?
Not off the top of my head.
Okay, but is that address located, I guess, in the city of Lansing, in Ingham County?
Yes.
All right, and so you stated you were at the bar with friends. Were you drinking that night?
Yes.
Okay, would you classify yourself that night as intoxicated?
No,
Okay, and why not?
I only had a couple of beers because I had a dry pack, so probably like one or two over the course of about 4 or 5 hours.
Okay. And so at some point you left the bar, correct?
Yes.
And where did you go after that?
Back to the house where my car was parked at.
Okay. And what did you see when you got back to the house where your car was parked?
I had 3 tires slashed. The back window was busted. The back windshield wiper was broken off. The gas cap and cover were ripped off along with the driver's side mirror. And then I had scratches along the driver's side and the back.
Okay. Now, I'm going to go a little off topic here, but do you know an individual by the name of Marvin Gray?
Yes.
And how do you know Marvin Gray?
He's my friend.
Okay, and how long have you been friends with Marvin Gray?
For about 2.5 years.
Okay, and to your knowledge, is Marvin Gray related in any way to Catrice Gray?
They were married.
Okay. All right. So getting back to getting back to the night of the incident, did you see who? So you said you arrived back from the bar and your car was damaged. Did you see who damaged your car?
No, not in person.
Okay, so now how did you eventually see who damaged your car?
There was a camera on the house.
Okay, and did you witness that video?
Yes.
Okay. At this time, Your Honor, I would move to play people's proposed, or I should say people's stipulate to admit Exhibit 1.
And for purposes of appeal, Your Honor, we're stipulating.
Okay. So you would just have to share screen, but you have to click sound before you share.
Yeah. I'm going to. Same thing. Okay. It's an awkward video, Your Honor, so I'm going to pull it up on our evidence here so I can rotate it so that it's oriented to what would be seen from a regular perspective,
Okay.
but it is the same video. Um, I'm unable to hear the host is disabled.
Did I do that? We had a Zoom pirate in here. Let me see that. Give me just a moment. You're the host now.
Um, So I'm at this time I'll be playing People's Exhibit 1.
Okay.
I'm gonna pause it right here for a second. And is that your car there in the street?
Yes.
Okay.
Oh,
Yeah,
okay.
there's no sound.
Sounds good.
Not sure how to make you the host again.
If we could leave it like that, just in case I need to
Okay,
replay it.
that's fine.
That'd be okay.
Is it all right if I leave it up there? Okay. Um, So, Ms. Richmond, is that a fair and accurate representation of the video that you saw that night?
Yes,
And based on the look of it, was that the original video or was that a recording?
I recorded the original video with my phone.
Okay. Now, can you see the face of the individual who was next to your car there?
No,
Okay, so you told, I guess I say you told police that you knew it was Miss Gray. How did you know that that was Miss Gray?
knowing that her car is exactly like a similar match as a black car, smaller, and then also her body type, the same size and height as the car.
Okay, and do you know this from personal experience you've had with Miss Gray?
Yes,
Okay. So when you reviewed the damage to your car, what damage was there to your car that was done that night?
I had 3 slashed tires. The driver's side had been keyed along with the back front door. The driver's side mirror was ripped off. The gas cover and gas tank lid were ripped off. The back window was smashed, and there's actually a beer bottle still in the back of my car. And then the back windshield wiper was also ripped off.
Okay. And so after you found that damage to your car, what did you do then?
I tried to report it and then make a police report.
Okay. And so after you made the police report, did you ever contact, or I should say, did you drive your car away that night?
No, I left it parked there until it took to fix it up.
And why did you leave it parked there?
I didn't know if anything had been poured into the gas tank
Okay.
and caused further damage to the vehicle.
Right. And so you said a tow truck came and picked it up. Did you call that tow truck?
The insurance company did.
Okay, so you made a report to your insurance company then?
Yes.
Okay. And so the insurance company, you said, sent a tow truck. Do you know where they took that, where they took the vehicle?
I'm not sure. I know it was a collision shop.
Okay. And did that collision shop do an evaluation on the amount of damage in terms of parts?
Yes.
That was done? And how much was that damage?
The parts was about 4,600, but the total damage with parts and labor was going to be about 9,300.
Okay, and so did you get that car repaired?
No, it was total.
Okay, and was that the decision made by the insurance company?
Yeah, the insurance company.
Okay. One second here. So you said, going back a little bit, do you have any idea why Miss Gray would damage your car? like
Objection,
this?
Your Honor, calls for speculation.
You want to address the objection?
One second. Yeah, I believe the witness can testify to what she believes happened. It's not being offered for the truth of the matter asserted. And in terms of the destruction of property, but I believe the witness can testify to why she.
If it's not for truth of the matter, asserted, Your Honor, then relevance at that point, because it's not relevant what she thought my client was thinking at the time, even though it's complete speculation as to what my client was thinking. Or how she could lay a foundation for what my client was thinking.
The question is, does she have any reason, or does she have any knowledge as to why she believes the defendant would have caused this damage? Is that the question?
Yes, Your Honor.
Right, it's not being offered as hearsay, so for.
Right, that's what I was gonna say here, that truth of the matter asserted is for hearsay, so that doesn't apply here, but
Your
it
Honor,
does cause for speculation.
Your Honor, I think it would apply if he's not using truth of the matter asserted, then there's just no relevance for it. It's pretty much an admission, there's no relevance.
But I think it would cause her to speculate. So based on that objection, I'll
I
grant
can rephrase.
the objection.
Your Honor.
So, Ms. Richmond, do you have a good relationship with Ms. Gray?
No.
Okay, and why not?
Because I was friends with her then husband, and now so she just doesn't like me just based on that.
Okay, and to the best of your knowledge, were Mr. Marvin Gray and Ms. Catrice Gray married at the time of this incident?
I believe so.
No further questions at this time, Your Honor.
Cross-exam.
Thank you, Your Honor. Ms. Richmond, what kind of car did my client drive at this time?
She had just gotten a new car not too long before that. So I'm not
She had a what?
sure. It was a black Ford, like a black Ford car.
And that's what she was driving at this time?
That's what she drove in the video, and I had seen her.
No. What, did you ever see what kind of car she drove?
Yes, I saw
Okay.
her at a party.
What kind of
before
car
that.
did she drive?
A black short Ford.
Is it a black short Ford?
Yeah, not like a Ford Focus, but a little longer.
And you also said that she recently bought a new car, or
That
since
would
this
be the
incident, she
new
bought a
one.
new car?
That would be the newer car.
Okay, so the car, what you're seeing here is the newer car?
Yeah.
And the newer car, is that the black short Focus?
Not Focus, I just said black Ford.
The car that we saw there is the short black Ford?
Yes.
And did you ever see my client driving the short black Ford?
Not in person.
Okay,
Wait, I'm confused. You've never seen her drive?
No, but I've been to multiple locations where she has been with the same vehicle.
But you didn't see her drive it?
No.
So how do you know it was her vehicle?
I was told that she had gotten a new car.
and it's purely based on this video that we watched here in court today that you made identification, is that right?
Yes.
When did you say this incident occurred?
It was November 27th around 11 p.m.
27th? The evening of the 27th?
Yeah, 11 p.m.
You sure?
The video has 1123.
So the video has what?
At the bottom of the screen, it says 2300,
Down at the bottom.
which is military time for 11
Well, that's
p.m.
military.
Right, but we're talking about the date.
Oh,
There should be a timestamp on it, Your Honor.
if I, it may have been.
Yeah, I noticed that. I already had a note on it because it's different from the date that was questioned at the beginning. So that was one of my follow-ups, but I was gonna let you cross-examine first.
There,
Do you have, where's the original? Oh,
I'm sorry, Your Honor.
Probably.
Yeah.
Your Honor, we're preparing and not neither myself,
Yeah.
nor is Berkowitz, realized that the timestamp was cut out of this one, Your
Yes.
Honor, and it's
My apologies.
neither here nor there. No, I didn't catch the objection either, but we are putting up this was more or less for ease. It's easier to see this video here. Mr. Borowitz, I believe, is sharing, there it is. He's sharing the current, what we got there. The only problem is we can't spin it, and that's why we use the other one, Your Honor.
Yeah, when the video first played, whatever video we're using, it did show that date. That's what I wrote down.
Oh, it may be.
But it didn't show it the whole time, just at the beginning.
If you know, this incident occurred around the Thanksgiving holiday, is that right?
Yes.
Do you know, was it on Thanksgiving?
No.
Are you at all aware that my client was in Muskegon, was celebrating Thanksgiving with family?
No.
Your Honor, at this point, I would object. The people have had no, well, we've had a somewhat prior notice that there was a possible alibi defense. However, that was earlier this morning. People had no notice of it prior to that. And so people would object to any alibi defense being offered here.
With preliminary examination, I think it's just questioning.
It was a question of whether or not she had knowledge of that. She
Yeah,
said no.
Any defense would not be at this time.
Well, and we appreciate the objection because we're obviously still investigating that, make sure we pull all of our witnesses together who were with her during the holiday, Your Honor, so that we can actually present this to the court and hopefully resolve this matter, but we appreciate the objection.
Thank you. For the record, the objection is over.
Ma'am, you said that your car was totaled, is that correct?
Yes.
What was the value of the totaled car?
The value of the damages?
No, the car itself. The damages were more than the car was worth, correct?
Yeah, well, that was more than what I owed to the credit union. Now with the
Do you
car.
know the value of your car?
It was about $12,000.
Your Honor, I have no further questions. Thank you.
Okay, let's see. You indicated in your direct that you have prior experience with the defendant, which caused you to believe that that was why she would have been the person to do this to your car? Is
I
that
know
correct?
she did not like me, and
What makes you believe that?
I have seen messages from other people that say like, why is she here? And then we're not in the same space at the same time ever.
You're never in the same time in the same space?
Just because of conflict. like,
Okay. And so you've not received messages directly, you've seen other people's messages?
Yes.
Okay. How would the defendant have known where your car was?
It was at one of the friends' houses, the cousins. So
Whose
the-
friends?
My friend.
Okay.
So because it's a family house, that's like one of the hangout spots. If you're not doing anything, you just come on over. So it's one of the places that if you're looking for somebody, you might check that as well.
Your family's house?
No, my friend's.
Your friend's house?
Yeah.
Okay. But my question was, how would the defendant have known that your car would have been there on that date and time?
It was the birthday party we went out for, so she might have thought the party was at the house.
Who?
My friend Bree,
Who would have thought the party was at the house?
the defendant.
Oh, the defendant was invited to the party?
No.
What makes you think the defendant knew about a party?
Every birthday, there's usually a party.
Every birthday?
Yes,
For whom?
just anybody who has a birthday.
Oh, okay. Redirect.
Just briefly, Your Honor. So going back to just briefly when you said, so do you, after me, do you recall what date the party was and the damage hand, what date range that was?
It would have been November 27th. So I
Was-
believe it was a Saturday.
And that was the date of was that the date that the damage was done, or was that the date of when you saw the damage?
That would have been, I saw it Sunday, November 28th. because we came back about 2 o'clock in the morning.
Okay, and did you call the police that day or?
I have called them in the morning.
Okay. And then when you say it was, you knew the type of car she was driving, was that, I was asked, was it a, it was a, what would be classified as a car, more like a sedan, is that?
Yes.
Okay, and did that car have 2 or 4 doors?
4.
And the car we saw in the video, did that have 2 or 4 doors?
I couldn't tell from not seeing it on the video.
Okay, would you like me to replay it?
Yes, please.
To refresh your memory? Yeah, this.
It has 4 doors.
Okay. And is that the type of car that you had seen the defendant in previously?
Yes.
Objection, Your Honor, that's, well, one, it's leading to the fact that it's outside of the scope of what you already testified to at this point.
Do you want to respond to the?
I would say that the defense brought up on their cross-examination that in reference to the type of car that the defendant was driving and whether or not she had seen the defendant in that car. So I believe the defense opened the door for that on redirect.
Okay, objection to leading is sustained. The other objection overruled. So you need to rephrase your
Right,
question.
Did you ever see the defendant in that type of car?
Not personally.
Okay. Now, when you say you described the car as short, when you were describing it as short, was that in terms of its height or of length of the car?
Your Honor, I'm sorry, I'm gonna check again here on 601, personal knowledge at this point. She's already said she's not seen my client in the car. Now the prosecutor's trying to have her testify about what kind of car it is, what it looks like.
Yeah, she's never seen her. She said it more than one time in the car. I don't even know how she knows it's short or what it is if she's never seen it.
Okay. And then you said when the judge asked you how the defendant would have known that you were at that house, is the defendant also friends with the individuals whose house you were at?
Yes.
Okay. No further questions at this time, Your Honor.
Okay. I made questions, so I'll give you an opportunity to process any of the questions I had.
No, Your Honor, I got no questions. Thank you.
Thank you. May this witness be excused from the stand.
Yes, Your Honor.
Thank you. Do you have any other witnesses?
No, Your Honor.
Okay, I'm gonna actually have you replay this video because
Okay. Would you prefer this version or the rotate?
definitely the rotated one.
Okay. Just wanted to make sure.
I'm sorry. She can wait because I might have a question about what I'm seeing. Okay. This witness can be excused. You can present any other evidence at this time.
People have no other witnesses at this time, Your Honor, no other evidence that people would rest at this time.
Will the defense call any witnesses?
No, Your Honor, no witnesses for defense.
This is argument.
Thank you, Your Honor. The people would ask that this be bound over as charged to circuit court in the complaint. The people have established that this incident happened in the city of Lansing, Ingham County, though the witness could not identify the exact location. The witness also made identification as to the defendant, and she identified the defendant as the individual in the video based on prior knowledge and prior experience, as well as physical attributes in relation to the height of the vehicles and the way the defendant was moving in the video, or the individual in the video was moving. As to date, the witness was on or about the date in question here. I believe that would be matter of fact, the jury. And as for the elements, again, the victim did the victim did testify that her car, when she came back, was damaged, and that the damage of that, after she reported it to her insurance, and the insurance took it to a body shop, that the estimated amount of damage in terms of parts was around $4,600, meeting the limit of 1,000 or more, but less than 20,000. And so with that, the people would ask, the people believe they've met their burden by a probable cause standard and would ask to find this over as charged in the complaint.
Thank you, Your Honor. First of all, as to the date, it was pretty unequivocal with what the witness had said. Not a matter of controversy there, when she said it occurred on the 27th. There's clear evidence based on the prosecutor's evidence here that it occurred on the 26th. And that just initiates the plethora of issues we have with this witness, her accusations here, and I mean, even some of her base comments here. First and foremost, regarding this relationship, unless I wrote it down wrong, it's my understanding that from May of 2020 to the summer of 2020, they may have worked together at this cleaning place. And apparently there was some building animosity that grew to the point where there's going to be destruction of someone's car 2 years later. Moving forward from that, Your Honor, just looking at this and looking at really the only evidence we have, which is the video, the identification was made for the video. Apparently we're seeing damage done in the video. We almost don't even need this witness because everything was done through this video. The court can plainly or cannot plainly see who it is. It's difficult to see body type and size. We don't have an identification of face. If we're saying body type and size, we are saying someone who is between a certain range and is between a certain weight. That does not, that includes a vast and overwhelming number of people. Two, the damage that was allegedly done, the destruction of the windshield, ripping off of the mirrors, scratching on both sides of the car. Whoever this individual is in the camera and walked to the side once, never went around to the very front of the vehicle to throw anything, seemed to have been in the back of their own car for majority of the time. You couldn't even see damage being done, and we have to question whether or not what we're seeing is actually damage occurring. And the reason that's important here is because this is the date, the time, the individual who they're claiming committed this. There's just absolutely no evidence. It is staggering to think that we even initiated charges on something like this based upon this video. I mean, just with the identification alone, two of the main things prosecutor has to prove is date and ID in every single preliminary examination. They haven't been able to meet either of those. This isn't a matter for a jury to decide. This court can look at this and say, no, you didn't get the date right. The identification is deplorable in this matter. And the client, the victim never saw the individual's car. Yet is somehow saying, oh yeah, I know her by the car she drove. Yet never saw my client in whatever this new car is, can describe the car in the exact same way that everyone in this room can describe the car as being a black sedan. I don't know how we measure short or not, Your Honor, but this is the evidence we have here. The people are saying that they've got probable cause at this point. If there was ever a measure and a purpose for preliminary examination to protect individuals from just pointless prosecutions, this is exactly what it is, Your Honor. I'm asking the court dismiss these allegations against my client based solely on what we have seen here on these witnesses and everything else I put forward. Thank you, Your Honor.
Thank you. Today was a date and time that was set for preliminary examination. The purpose of the examination is to require the prosecution to meet their burden. They have a burden of proof of establishing that they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with the crime. In this particular case, the crime is charges 1 count of malicious destruction of personal property, 1,000 or more, but less than 20,000. And so probable cause is not a standard to be compared to that. That would be their burden if they go to trial. If this matter goes to trial, they have to prove each element beyond a reasonable doubt. Today, the measuring standard is more than mere suspicion. And it's a common sense standard. It's flexible. It's based on the circumstances presented at the time of the examination, the court being the sole determiner of credibility. I also have to measure the probability that the government or the prosecutor would be able to establish guilt at the time of trial. And I also should be measuring whether there or not the evidence raises reasonable doubt about the defendant's guilt. I have here testimony from a Tar Richmond who states that, I think her original question, it was November 28th, because that's the date I wrote down. But now it may have been the 27th or the 26th, because she did later state the 27th. Video shows a time stamp of 26th of November 2022. So somewhere in between November 26th and November 28th, Miss Richmond was at a bar for a birthday party. She parked her car in a street that she's unaware, unsure of the name of the street. She's unsure of the address of the friend that she was parked in front of. But when she returned, she states that she had 3 tires slash windshield broken, some scratches, gas cap damage, and other damage done to the vehicle. She alleges that she believes the damage to have been done by the defendant, and that's based on, she says, a similar car and body type in personal experience. And so the court questioned Ms. Richmond personally about what the personal experience was. And it's the response the court got from Ms. Richmond was that she had not had any direct interaction with the victim, but that she may have seen some text messages from some other persons about why is she here or that nature. But there's been no allegations, at least no testimony today, about any threats or any personal interaction that she's had or any statements that came directly from the defendant to Ms. Richmond. Then when questioned about the defendant's similar vehicle body type, it was later determined Ms. Richmond never actually seen the defendant's vehicle. She's never seen it. She's heard, someone told her about a vehicle is what her statement was. And so she's never seen or drive a black vehicle. So she can't give any testimony as to the type of vehicle in which the defendant drives. If there was someone who told her or identified that as possibly being the defendant's vehicle, that person should have been sitting in that seat today, and that person was not there. Also, the court questioned or asked the video to be replayed. We saw a video, we see it, someone pull up. I see someone who's curvy pulls up. I can't identify from the video if it's a male or a woman. I can't identify from this video a face of any kind. The person pulls up. I can see the person in their trunk for some period of time. It does look like they walk maybe back to the car or maybe into the front. The testimony was that there were 3 tires sliced or slashed. There's only 2 tires on that side. So at some point, someone would need to have been on the other side of that vehicle in that video. I saw that not one time. In addition to that, there should have been something seen on the video or visible that would show me some damage being done to the windshield as alleged. I asked the victim, how would the defendant even know where your car would be parked? Because she testified she's at a friend's house, that she didn't even park her car at the friend's house. She parked it at a street near the friend's house. Well, how would this person, who you never had any direct communication with ever in your life, that would know where your car is? And her statement was, well, obviously there was a birthday party. I said, is she invited, was the defendant invited to the birthday party? She says no. Well, how would the defendant know that there's a birthday party? Well, everybody has a birthday party whenever there's a birthday, was the response. What we have in this case is mere suspicion, but not more than. And so the standard has not been met, and therefore this case is dismissed. I need you to return
Yeah,
post authorities.
I'm not sure how to do it.
You gotta show them how to fix the host.
I could, yeah, I could just close Zoom.
If you leave, it'll have you assign somebody.
Yeah. Ending. You good?
Yes, please. Okay. No additional matters on that record, I presume. Thank you. Okay, and then we just need Mr. Lee is here. Very good. Mr. Lee, did you need to speak to your client at all?
No, ma'am, I believe we're ready to proceed.
On the record in the matters of the people of the state of Michigan versus Michael Johnson, file numbers 23-00622 and 23-00860. SM council appearances.
Jeff Reynolds on behalf of the people, Your Honor.
Ruth Goodrich from the Public Defender's Office here to represent Mr. Johnson on file 23-622 FY.
Assistant Public Defender John Lee, representing Michael Johnson on case number 23-00860-SM.
Okay, today was the date and the time set for sentencing. The court has, I'm sorry, pre-sentence reports on both files. Attorneys both got their respective copies of the sentence report.
Yes, Your Honor.
Yes, Your Honor.
Any need to make changes, updates, corrections, or deletions?
No, Your Honor.
No, Your Honor.
just wanted to see. Identical to look like it to me. You can make allocution.
Thank you, Your Honor. Your Honor, Mr. Johnson has now served 56 days on these matters. Well, at least on my file. These are it's a 93-day misdemeanor. However, he has the opportunity as part of the plea to earn HIDA and 769.4A on these two files. Rather than sitting in jail for 2 weeks and being done, Mr. Johnson wants the chance to earn those non-public records by completing probation. He believes that it would be helpful for him. He has difficulty dealing with conflict, and he thinks those classes would be beneficial because he doesn't want to end up back in front of the court. He understands that, you know, any contact with Ms. Lee going forward have to be through a third party regarding the exchange of their child. I don't believe he has any desire to have contact with the woman from the other file, Ms. Johnson. He is currently unemployed, but he's looking at getting work at either Taco Bell or Wendy's. He has a sister who works at Wendy's, and he thinks that might help get him in there. So we would ask the court to sentence him to a term of, let me make sure I have the. Which one?
You're on the felony file.
I can't remember if that's the HIDA file or the 76948 file.
I want to say FY is the one with HIDA.
Okay, on the HIDA file. The one thing I would object to as part of the recommendation was the scram tether. He's unemployed and has minimal resources, as that is stated in the pre-sentence report. I don't think he's going to have any ability to afford a scram tether as recommended. So I would just ask the court to have him do the more of the standard random testing, the 2 times a month testing. I think that will be sufficient. I don't believe substance abuse. While he did admit that he has used marijuana, I don't believe substance abuse was a factor in this. He does have some cognitive issues, which make some things difficult. But like I said, we would ask the court to follow most of the recommendations outside of that, Your Honor.
Okay,
Your
FY is the 769.4A.
We would ask for that stance.
Just a moment, Mr. Lee, so I can look at it. Because okay, Mr. Lee, you can make allocution.
Thank you, Your Honor. We would reiterate many of the things that Mr. Goodrich has said, including the fact that the long-term benefit of Mr. Johnson would be most furthered by focusing on counseling for anger management issues, education, getting a GED, and perhaps part-time employment. There does seem to be an inordinate amount of focus and attention on marijuana use and drug counseling. We don't think that that's necessary, but we do understand that he does have some long-term goals that need to be at least partially addressed via the probation, and we are certainly open to that. He wants to do the probation for his HIDA status and is asking the court to, again, consider his lack of resources in not only assessing fines and costs, but also in the length of his probation. 18 months just seems like a very long time for a 93-day misdemeanor. We're asking the court to consider 6 months to a year as a maximum term of probation.
The court's reviewed the pre-sentence report and recommendations. We've also reviewed the prior criminal history. The recommendation is for 18 months on each file, I believe, of probation. And it's not just because, well, it is a 93-day misdemeanor, but there's 2 files that were taken into consideration when the recommendation was made. So we have two separate files, both assaultive. And the author of the reports have to take that into consideration. And it looks like you scored moderate to high risk in personality characteristic domains. It's been clear that, or indicated at least by counsel on your files, that you do need to work on some things interpersonally, and then you also need to work on some things as it relates to structure. You need employment. You need to work on some anger management or how you deal with conflict. And a term of probation would be appropriate to oversee that. But there's also a substance abuse issue that should be addressed. That's what it appears here. I agree that starting you off on 18 months probation is extensive. I don't know that it's necessary, and hopefully wouldn't be necessary to address the concerns. If you make meaningful efforts, you can meet these goals in far less than 18 months. So we'll start you off with about half of that, okay? I'm gonna start you off with 9 months of probation. They'll run concurrent, so you won't be duplicating efforts. I think the most extensive report is in the FY file. As to your probation status, while you're on probation, you're not to have any contact directly or indirectly with Lisa Lee. I am the right file. Who's the mother of the child?
The FY.
Okay, well, Lisa Lee is the mother of the child, correct?
Yes.
Okay, you're not to have contact directly or indirectly with Alyssa Johnson. That's on the S. As to contact with Lisa Lee, have a child in common, correct? So third-party contact will be allowed. That's peaceful contact, that is, for the purposes of childcare, okay? While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm or ammunition or weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or a controlled substance unless you have valid prescription for that. You understand?
Yes.
You are required to submit to random preliminary breath testing. You are required to pay the cost of that, okay? You're not to be in any bars or nightclubs while you're on probation. In order that you complete a substance abuse weekend, I'm also going to order that you obtain employment. You'll need to provide verification of that to probation, okay? I'm going to also order that you complete batter's intervention. Provide proof of that completion to probation as well. Do you have any questions so far? File number ending in 860FY. I will grant status under 769.4A. File number ending. I'm sorry. Somebody, that's the problem. It's whoever sent this one. This should be SM. 860 SM. Okay. 860 SM HYTA is granted. On the FY file, we will grant 769.48, okay? As to fines and costs, in file number 622 FY, $75 crime victim rights fee will be assessed, plus a $50 state minimum cost that will also be assessed. Ordering you to complete 9 months of probation, that's $30 per month, and oversight fees, plus the other fines and costs that I spoke of, because I'm going to waive discretionary fines and costs, will come to a total of $395 on that file, okay? File number 860 SM, there's a $75 crime victim rights fee, plus a $50 state minimum cost. That's a total of $125 there, because you don't need to pay oversight fees twice. You're gonna run probation concurrently on that, okay? If you have any questions about probation, I want you to review that, advice and rights as to probation, and then you'll let us know if you have any questions.
Your Honor, one last thing. I just want to make sure the court is dismissing the old PA 53s that were as part of the plea, that they would not be sought in this case. Make sure there's nothing left holding them in jail.
That is correct. It says but the court has dismissed the PA 53s. Do you have any questions about that advice of rights, sir? Still at the address on 8th Street?
1820, yes.
Oh, okay, sounds good. And no questions about advice of rights, correct? Additional matters for the record, counsel?
No, Your Honor.
Nothing further, Your Honor.
You're all set, and go up to you, sir.
Thank you, Your Honor.
Thank you.
Yeah, just to remind us, it was there were 2 classes with batter's intervention, and what was the other one?
He's gonna do the substance abuse weekend.
Oh.
Right.